The second act in Donald Trump's legal double feature today occurred about 200 miles south of I-95 from New York. While some of his legal team spent the entire day in the courtroom in Lower Manhattan, other lawyers were arguing before justices at the Supreme Court on Trump's claim of what he calls absolute immunity. Now, they were signaling today that they could very well send this case back to a lower court, which of course would delay the special counsel's 2020 election subversion case that was supposed to start back in March. It's almost May. But they also sounded skeptical about Trump's blanket immunity defense. Trump lawyer John Sauer argued that Trump's actions were official acts of the office. But in one exchange, the Trump-appointed Justice Amy Coney Barrett questioned what exactly was an official act and what was a private act to benefit Trump.
Petitioner turned to a private attorney who was willing to spread knowingly false claims of election fraud to spearhead his challenges to the election results. Private?
As alleged, I mean, we dispute the allegation, but
Of
that
course.
sounds private to me.
Sounds private. Petitioner conspired with another private attorney who caused the filing in court of a verification signed by petitioner that contained false allegations to support a challenge.
That
Private.
also sounds private.
3 private actors, 2 attorneys, including those mentioned above, and a political consultant helped implement a plan to submit fraudulent slates of presidential electors to obstruct the certification proceeding, and petitioner and a co-conspirator attorney directed that effort.
You read it quickly. I believe that's private.
With me now is Jack Rakove, Pulitzer Prize-winning author, historian, and professor at Stanford. He'd also signed onto an amicus brief to the Supreme Court rejecting Trump's immunity claims. Thank you for joining us this evening. It sounds like this immunity question may not be close to being resolved completely and could actually go back to the lower courts. What is your opinion of if that were to happen and you don't get the answer resolved fully by this Supreme Court?
I suppose my basic answers would be a political disaster for the country as a whole. And I think the basic reason for that is that speaking in a sense on behalf of the founders, which is what the historians group of whom I'm a part have been studying, I think the framers of the Constitution, the founders more generally, would have expected a matter of this urgency to be resolved in advance of an election and not to be kind of slow walked at the quirky pace we've been moving at, so that people would not be able to have an informed judgment about the qualifications of a leading candidate.
I mean, as you describe it, it makes sense to think that the idea of whenever you have a president, you want some urgent clarification as to what the bounds of their power actually is. Elections are important, but also there is a president right now. I wonder what you made of the hypotheticals that were proposed about the future. There was not a lot of time spent on January 6th or election subversion case, but more, as I think it was Gorsuch who says, deciding a case for the ages. What did you make of the focus from this court on this issue?
Well, the issue is so anomalous, just as Trump's behavior is so anomalous, that the idea that you can take the, on the one hand, quirky, but also really deeply troubling circumstances that surround January 6th and say that on the basis of that one situation, you can decide a case for the ages will strike most legal commentators, certainly most historians, as being a deeply problematic statement. I think Justice Barrett, in her exchange with Sauer, the petitioner's attorney, I think she nailed the key points. That there were a number of very specific matters that one should focus on. And Justice Alito, when he intervened in his own way, kept trying to deny the importance of the immediate issues to kind of speculate about what might happen in the future. We have an urgent issue right now. That issue needs to be resolved. We can worry about the future when the future comes. We have to get through the current crisis of the Republic, which is why the court should be acting expeditiously.
Well said. I mean, listen to this exchange as well between Justice Elena Kagan and Sauer about this hypothetical question of prosecuting a former president who, for example, staged a coup.
I don't feel like leaving office. I want to stage a coup. Is that immune?
If it's an official act, there needs to be impeachment and conviction beforehand because the framers viewed that kind of
If
very
it's an
low
official
risk.
act, is it an official act?
If it's an official act, it's impeachment.
Is it an official act?
On the way you've described that hypothetical, it could well be.
Now, of course, in your amicus brief with other historians, you forcefully argue against this assertion that a president can only be prosecuted only after being impeached and convicted. So what do you make of his answer that he gave today? And I would note he also doubled down earlier on this assertion that a president could order, say, SEAL Team 6 under an official action to even hurt a political rival.
From a historian's perspective, we don't deal in hypotheticals. We do with things that actually happened and views that people actually adopted. I think the most important thing we'd say is that in the 17th and 18th century, both England and America, the dominant theme in constitutional thinking was how do you cabin, how do you control, how do you restrain, how do you constitutionalize executive power? Souery, the attorney, made a big point of appealing to the vesting clause of Article 2, which says the executive power shall be vested in a president of the United States. That clause has been carrying a lot of interpretive weight recently, probably more than it really deserves because it's adopted very late and without much discussion. But if you ask the question, what is the nature of the executive power that is vested in the president? I think the historian's first definition would be that he shall take care that the laws be faithfully executed. And I think the best commentary on this actually came from John Dickinson at the Federal Convention, where he says that the real virtue of vesting the executive power in a single person, it's not the question of acting with energy and with dispatch. Those were two terms that the framers used. It's also the question of responsibility. So the idea of recognizing this open-ended, unconstrained, in certain ways unimaginable degree of immunity, there's no way you can square that with the dominant value of Anglo-American thinking from the late 17th century down into the time of the Revolution and the Constitution, which tries to make executive power responsible, and indeed which concentrates the executive power in a single person to enhance that end. So the whole immunity argument would strike all the historians, my friends and colleagues who were the co-signers of the brief. It just strikes us as being, in a certain sense, historically nuts.
And that's why we need historians. Thank you so much, Jack Rakove. Thank you so much for joining us tonight. I want to bring back in our panel.
Historically nuts. I like
Historically,
that.
I mean, that's
a good one.
That might be a new brand. Something called Planters. Marcus, you were actually in the Supreme Court. And I'm just wondering what that was like in those moments. We were all listening to it and getting a sense from the outside. But what was the atmosphere like in there? Was it tense? Was it relaxed? Tell me about it.
So I remember the very first primetime hearing from a couple summers ago. It was probably the heaviest feeling I'd felt before a hearing. We wanted to get it right as a committee, and you just felt like a stress before it started. It felt the similar way.
Well, history was in waiting for you to act. That's probably what it is, huh?
It really was, and our work was going to be judged for history, right? And I felt like the Supreme Court, you could tell the justices could tell that what they were going to decide in the next month or two would be remembered historically. I mean, that's kind of how they started out. Trump's counsel saying that no president as we know it will be the same moving forward if they don't have absolute immunity, right? And so it just felt like it was a very historical moment. There were a few moments where jokes were made, like Justice Alito saying you can get a ham sandwich indicted, that made us laugh a little bit to bring it back. But it was a very tense, 2 hours and 45 minutes in that courtroom today.
I mean, go ahead.
I do not understand why the Supreme Court decided to take this case. I still don't, and especially now after today, because it seems pretty clear that the court has leeway to decide what they take, what they decide to settle, and what they don't. There are a lot of legal issues out in the world that are not settled. Not all of them need to be settled right now. This one does not strike me as something that needs to be settled right now. Why are they doing this?
Because Donald Trump is a candidate for president, and several of the justices were appointed by him. But I just want to...
do you think also that they might be worried about establishing those boundaries of where the presidential power is in the event of a Donald Trump presidency in which he might, test some of these things?
I agree. And I predict this. Justice Roberts, I believe, will be thinking about Dred Scott, Plessy versus Ferguson, the Nixon tapes case, and he will know that where he stands, majority-minority, will haunt him for the rest of his life. And he wants to establish himself in history. They read the papers. So I predict, I'm being a Pollyanna. I think Justice Roberts is going to do the right thing. And you could possibly see a 5-4 opinion rejecting absolute immunity, and it's Justice Roberts and the 4 women. I predict that could be it. I did want to add one last thing. Nobody's mentioned this. There should have been 8 justices hearing that case today. Justice Thomas, I teach legal ethics, Professor Kim does. There is no ethics lecture at law schools or any level that would say there's not an actual conflict or at a minimum an apparent conflict. He should not be hearing this case, period. End of story.
Well, you know, it's funny, we're talking about no more kings, the professor, this idea that historically the whole point of the revolution was no more kings, and we've created 9 kings. We have a Supreme Court that essentially has no accountability, and that's why we're in a position where someone with these egregious conflicts of interest that really give him an incentive to favor Donald Trump because his wife was involved, et cetera. There's all these public conflicts where they're justices being, jetted around by billionaires with interest before the court, but there's no enforcement mechanism for ensuring that these people are nonpartisan, other than life tenure, which ironically makes them even more, I think, above the law in this moment.